Good morning or afternoon, depending on where you are joining us from today. My name is Ed Redder, and I would like to welcome you to today's webinar. I am a partner in the Employee Benefits Practice Group in Thompson Hine's Columbus office. I am joined today by Dominic DeMatties, an Employee Benefits Partner from our Washington, D.C. office. Today, Dominic and I will discuss recent developments related to retirement plan investments, including ESG considerations, fiduciary considerations regarding cryptocurrency investments, and the fiduciary process for selecting and monitoring managed account services and brokerage windows. This webinar is the third in a series of 4 webinars we are presenting the second Wednesday every month at noon through the month of December. Each webinar explores a different retirement-related topic. You can register through the invitation you received or on the Events tab on the Thompson Hine website. To proactively address questions, today's webinar is being recorded and will be sent to all registrants within approximately 2 business days. During today's presentation, please feel free to use the question panel at the upper right-hand corner of your screen. We will answer questions at the end of the webinar as time permits. And now we will begin today's presentation. As I mentioned, our first topic today will be on ESG considerations in retirement plans, and that will be followed by a discussion on brokerage windows, managed accounts, and cryptocurrency, all of which are seemingly separate and distinct topics, but as we go through the presentation today, we'll see how they are intertwined and how decisions among some of the different topics can certainly influence decisions in other areas. So again, our first topic is ESG considerations in retirement plan investments. Certainly, I think we all have experienced, either in the press or in our own personal experience, the kind of proliferation of socially responsible investing, or investing that considers ESG factors or is focused on a certain social outcome. And those considerations have grown in the investment community. I had a colleague of mine who's an advisor tell me and share some statistics with me that $1 in $3 of professionally managed assets take into account socially responsible investing factors. However, within the retirement plan area, only a very small percentage of those dollars take into consideration ESG factors. And so as we walk through this segment today, I think the reason why will likely become evident to those in attendance. So to provide some context to this discussion, I think we should first step back and talk about, the particular area we're addressing, and that's ESG factors and considerations for investments within ERISA-covered retirement plans. And so this may be simplistic, but when we talk about the plans, we're really talking about retirement plans that are sponsored by private employers. And we know that under ERISA, every plan has to have at least one named fiduciary that's responsible for the control and management of the operation and administration of the plan. And so that certainly includes the selection and monitoring of investment options within a plan. Quite often, the company, the plan sponsor, the default is that the plan sponsor serves in that capacity as well, but not always the case. And certainly, we see in operation that the named fiduciary in the plan often delegates those responsibilities to one or more people to address for the plan on a going forward basis. And so with that, let's talk about the basic ERISA fiduciary standards, just as a reminder to everyone. Among other obligations, ERISA requires a fiduciary to discharge his or her duties with respect to a plan solely in the interest of participants and their beneficiaries for the exclusive purpose of providing benefits to participants and beneficiaries and defraying reasonable expenses of administering the plan. So that's kind of where our duty of loyalty under ERISA arises. But they also have to do it according to a standard of care. And so they have to discharge their obligations with the care, skill, prudence, and diligence under the circumstances then prevailing that a prudent expert acting in a like capacity and familiar with such matters would use in the conduct of an enterprise of a like character and with like aims. So that kind of provides us with the backdrop, the framework for this discussion. I would also say that many fiduciaries, many named fiduciaries to plans don't always have the expertise necessary to discharge their obligations under the duty of prudence, certainly. And quite often they will engage investment advisors to assist them in discharging their obligations. And so, based on the duty of loyalty and duty of prudence, there's been a concern on the part of the Department of Labor over the years that ESG investing or socially responsible investing or investing that takes into account collateral benefits, generally involves a selection of investments that serve some goal or end that is collateral to the performance of the investment. And if it's a collateral benefit, right, it could arguably be inconsistent with ERISA's duty of loyalty. Again, we have to act for the exclusive benefit of our participants and beneficiaries. This has resulted in the issuance of various and, again, varied sub-regulatory guidance on the topic over the years. And I'll share with you at least a partial list of the guidance. So beginning in 1994 and as recently as 2018, at least prior to the first final rule, the DOL provided a series of sub-regulatory guidance on the application of ERISA fiduciary standards that serve some collateral purpose. And I should call out here, if you look up the listed items, the listed guidance here, you may not see ESG, environmental, social, and governance factors, specifically referenced. That may be noted as economically targeted investments or investments that serve collateral benefits, but we're really talking about the same thing. And what you'll find if you read through the guidance is that, at least on the surface, it seems inconsistent over time. And quite honestly, it's been a swinging pendulum, and largely based on the party in office at the particular time the guidance was issued. And so, with this backdrop, with this kind of swinging pendulum of guidance, it really has created some uncertainty in the market, and certainly uncertainty for plan fiduciaries trying their best to discharge their obligations under ERISA and under the fiduciary standards. Well, that changed. Almost 2 years ago to the day, the Department of Labor finalized and issued their final rule titled Financial Factors in Selecting Plan Investments, which became effective January 12, 2021. And so according to this rule, the selection of investment options to serve non-pecuniary interests raises fiduciary concerns under ERISA. And under ERISA, a fiduciary must evaluate investments solely based on pecuniary factors and not subordinate plan participants and beneficiaries' pecuniary interests to achieve non-pecuniary goals. Well, I've used the term pecuniary interest several times already on this slide, so let's define it. A pecuniary factor is one that a fiduciary prudently determines is expected to have a material effect on the risk or return of an investment based on appropriate investment horizons, consistent with the plan's investment objectives and the funding policy. So again, fiduciaries, according to this guidance, according to the first final rule, fiduciaries are obligated to focus on pecuniary factors and really not collateral factors. There is one limited tiebreaker exception, and it provides that if a plan fiduciary is unable to distinguish between two investments based solely on pecuniary factors, the fiduciary may use non-pecuniary factors to make an investment decision. If they do so, though, the fiduciary must document why pecuniary factors alone were insufficient, how the selected investment varies from alternatives, and how the pecuniary factors used are consistent with the participants' and beneficiaries' interests. And just to step back, that seemingly is a pretty high standard, right? The two or more investments have to be indistinguishable from one another based solely on pecuniary factors. And I somewhat scratch my head and say, boy, isn't there some objective measure that we can virtually always distinguish two investments from one another? So it does seem to be a very high hurdle. And then in addition to that, you have to explain it and document why those factors alone are insufficient. And then the third point too, how the non-pecuniary factors used are consistent with the participants' and beneficiaries' interests. Again, how do we make that determination for the plan? Certainly, there could be certain participants and beneficiaries within the plan, within a large plan, that have different views from other participants. And so I think the structure of the first final rule, and we're calling it the first final rule because we're very likely to have a second final rule any day now, the structure really does chill at least reliance on this tiebreaker exception. So again, let's step back and reset. So we really have two paths for inclusion of ESG funds in plans. One, you make the determination, or a prudent fiduciary makes a determination that ESG factors are determined to be pecuniary in nature, or through application of the tiebreaker rule. I will say, though, and this is not explicit within the regulation, and I should also say that ESG references are not explicit within the regulation. In the preamble to the rule, though, the Department of Labor, and this is a quote, cautions fiduciaries against too hastily concluding that ESG-themed funds may be selected based on pecuniary factors or are not distinguishable based on pecuniary factors. So despite the fact that the regulation or the rule seemingly is neutral on its face, there does seem to be this word of caution from the Department of Labor and potentially kind of chilling language within the preamble, which I think has caused the market to somewhat recoil from consideration of these factors based on this rule. The rule also provides that an investment cannot serve as a plan's qualified default investment alternative if the investment's objectives, goals, or principal investment strategies include, consider, or indicate use of one or more pecuniary factors. And so, again, as many of you know on this WebEx or webinar, QDIAs are critically important within plans. It's where participants are defaulted to if they don't make an affirmative investment election. And oftentimes, significant percentages of the plan's assets are invested within the QDIA for the plan by virtue of auto-enrollment and the failure of participants to make affirmative elections within a plan. So this is a somewhat big deal too, and carve out from consideration of ESG factors. And so in sum, as you've probably concluded based on my comments, the rules had a chilling effect on ESG investing within retirement plans.
Ed, this is Dominic. Just one point related to that. Sorry, and sorry if my voice sounds a little scratchy. I've been fighting a cold, but I think I'm winning. Related to the chilling effect, and in particular the tiebreaker rule. Check me on this. I think I'm remembering it correctly. That doesn't the preamble also, or was it a press release associated with the final rule when it was the first final rule when it was published, say something to the effect of, and oh, by the way, we expect that there rarely, if ever, would be the need for this tiebreaker rule because we don't expect ties. Just underscoring your point that, yeah, there's a tiebreaker rule in that first final rule, but there's even chilling of the chilling, if you will, based on the language in the preamble.
Yeah, Dominic, that's an excellent comment. I agree with that. Again, from the Department of Labor's perspective, this is almost kind of a theoretical exercise, right? In the event that you're unable to distinguish between two funds or two investments based on pecuniary factors, you might be able to rely on this, again, if you document it all properly and can come to those conclusions prudently. But yes, I would agree with you that, yes, it has almost a double chilling effect based on the language of the preambles. That's a great comment, Dominic. And so again, fast forward to where we are, right, or right after the election. So we know in January of 2021, the final rule, the first final rule, became effective. Well, just 8 days later, President Biden took office and promptly ordered examination of the past administration's regulations, including the rule, for inconsistencies with the goals of promoting public health and the environment. We then quickly had a non-enforcement policy issued in March of 2021, which provided that the rule was being re-examined by the department. And until it issued further guidance, it would not enforce the rule. And then last but not least, we have Executive Order 14030, which directed the DOL to promulgate proposed changes to the rule. So as soon as we got started with the first final rule, we already saw the brakes kind of applied to its application. And that all culminated in the proposed rule that was issued on October 14th of 2021. And I will say that the proposal eliminates the concept of pecuniary and non-pecuniary factors and kind of steps back again and talks about a fiduciary's prudence duties based on appropriate consideration of facts and circumstances the fiduciary knows or should know are relevant to the particular investment or investment course of action and has acted accordingly. And so what does appropriate consideration mean? This is where we really see the difference from kind of the rule before the first final rule came out. Appropriate consideration includes, among other factors, consideration of the projected return of the portfolio relative to the funding objectives of the plan, which may often require an evaluation of the economic effects of climate change and other environmental, social, or governance factors on a particular investment or investment course of action. So now we have specific references, right, to ESG factors within the discussion of what appropriate consideration may be in the proposed rule. Now, taking a step back, though, I think it's important to have some context. And the preamble does a decent job of talking about this and framing this a little bit better. We have to realize that, I think from the Biden administration's perspective and the department, that the first final rule really did have a chilling effect, right? Not only in its text, but in the preamble. And so the proposal was largely a reaction to that chilling effect. And the administration, I believe, was trying to counteract that chilling effect. And so when we see references, we certainly see references to ESG factors, which is clearly a departure from the first final rule. Part of that was to, again, counteract the chilling effect and clarify that these factors very well may come into play and very well may, should be considered in a fiduciary's appropriate consideration of funds. The proposal also provided that a fiduciary could consider any consider any factor in the evaluation of investment that is material to the risk-return analysis, which, again, specific references could include climate change-related factors, governance factors, and workforce practices. Again, I think it's important to remember that this is in reaction to the first final rule. And certainly, the first final rule, I think, was somewhat consistent with this in its definition and use of pecuniary factors. So, again, on its face, it permitted consideration of any factors that were likely to have a material impact in the risk and return of investments over an appropriate time frame. So, which could have included climate change factors, governance factors, and workforce practices. But again, in an attempt to clarify and to counteract the chilling effect of the final rule, we have specific references. So in regard to a fiduciary's investment loyalty duties, a fiduciary may not subordinate the interests of the participants and beneficiaries under the plan to other objectives and may not sacrifice returns or increase risk to promote benefits and goals unrelated to the interests of the participants and beneficiaries in their retirement income or financial benefits. So we need to step back and keep all of this in context, right? This is not giving folks carte blanche to ignore performance, to ignore investment returns, to ignore the interests of the participants and beneficiaries, because certainly that would be contrary to the requirements of ERISA. But it is intended to provide some explanation and some roadmap for the consideration of these types of factors. So again, the evaluation of an investment must be based on risk and return for that the fiduciary prudently determines are material to investment values over appropriate time horizons. So whether a factor is appropriate really depends on the individual facts and circumstances that apply. And again, we have reference, may include climate change related factors, governance factors, and workforce practices. Further counteracting the first final rule, we have a revised tiebreaker. Here, and let's talk about the distinction between the standard. We have, if competing investments equally serve the financial interests of the plan over appropriate time horizons, the fiduciary may select the investment based on collateral benefits. So in contrast to two investments being indistinguishable based on pecuniary factors, we have what is seemingly a more relaxed standard, that competing investments equally serve the financial interests of the plan over appropriate time horizons. Now, again, it may be a matter of semantics, but it does seem to be a relaxed standard or a more relaxed standard. The rule also, or the proposed rule, also eliminates the special documentation requirements that were imposed by the final rule, and also seem to be an impediment to fiduciaries relying on ESG factors in appropriate circumstances. And then finally, if the investment is a designated investment alternative, the fiduciary must ensure that the collateral benefit characteristics of the investment are prominently displayed in disclosure materials to participants and beneficiaries. So it's not that you can't have it and can't consider ESG factors, or that the designated investment alternative can't consider those factors. It's just that we have to disclose those to the participants and beneficiaries. So what now? Well, the Department of Labor solicited comments on the proposal. We have nearly 900 comments were submitted, and the timing of the publication of a new final rule is uncertain, though, and Dominic, check me on this, I believe the rule's with OMB, and the release of that rule appears to be imminent.
Yes, we would expect it to be imminent in a governmental sense. Imminent to you and I might mean tomorrow, but right. imminent in this sense means, within the next month, maybe. Yeah.
So in the meantime, what do we do? What is a fiduciary to do with all that we've just discussed? And how do you digest that? How do you implement that? Well, certainly, I think, given the proposed rule, we certainly have the final rule on the books, but we also know we have the non-enforcement policy. We also know that we have a proposal and likely a final rule that will be issued in the relatively short term. Certainly, it dictates exercising caution in this area and restraint. I would say that a prudent fiduciary, to the extent you have an investment advisor working with you on a plan, should lean heavily on that investment advisor, but not blindly. I would certainly recommend that there be a dialogue between the named fiduciary or the investment fiduciary and the advisor to really understand how that advisor is, well, first, whether that advisor is applying any kind of screens or considering ESG factors, and then how they're doing so. Certainly with an eye of understanding at least how that's being done, how those recommendations are being colored by these types of factors.
Ed, that's an excellent summary of where we stand with respect to this ESG football, I guess we can call it. And as you described, this pendulum keeps swinging back and forth between Democrat and Republican administrations since at least the 1990s. And, it's interesting. This actually, is one of the relatively few areas where, party politics has kind of seeped into retirement policy, if you will. A lot of what we do on the retirement side, at least, is generally bipartisan, often bipartisan, I guess is a good way to phrase it. In fact, the next webinar in this series will talk about, which by that time we may know a lot more now that the midterms are shaking out, some pretty extensive potential bipartisan legislation that may be subject of a end of the year bill. So, it's interesting that this is kind of the way this has kind of gone back and forth a little differently than a lot of other retirement policy issues, just kind of pointing it out. But in thinking about this back and forth, I'm curious, Ed, you've looked at these rules very extensively. You've been on top of it, throughout the various iterations, at least since you've been practicing. Are there any particular ways in which let me preface this by saying, ever the optimist, looking for maybe a smooth path forward, or if there is a smooth path forward, or a smoother path, let's put it that way. So, along with that in mind, are there ways that this recent proposed rule, what you just described from the Biden administration, are there ways that it is maybe pared back from or softened prior Democrat administration policies, sub-regulatory guidance? In other words, I guess thinking about it first from the perspective of the current administration, do you see anything that's worth talking about in the proposal that may become final, that maybe is a concession or appealing back, or do you think it's all guns ablaze and the lines are as strongly drawn as they've ever been?
Dominic, that's an excellent question. I would say just very generally, right, first, that given kind of the volatility of politics these days and the rhetoric, do I expect that there will be more alignment between the administrations? I don't think so, at least with respect to the language that's used. But I think the narrower point, though, is when I look at these two rules, while they use different language and while the proposal specifically references ESG factors multiple times, I think if you really step back and evaluate them, I don't think they're diametrically opposed. I think there are a lot of consistencies. So just as an example, right, we talk about pecuniary factors in that the proposal eliminated reference to pecuniary factors. But the reality is, given the framework of ERISA and given kind of the basic fundamental factors that are used typically to evaluate funds, I think they're somewhat aligned. Appropriate consideration takes into account the same sorts of factors, and takes into account pecuniary factors without calling them maybe pecuniary factors. I mean, again, remember what a pecuniary factor is. It's a factor that is likely to have a material impact on the risk and performance of an investment option over appropriate time horizons. Well, certainly that's still embedded, if not by name, but it's still embedded, the concept, within the proposal. And again, I think we have to take into consideration the context of the proposal and the repeated use of ESG factors. Again, that was largely a reaction, I think, to the final rule, to counteract the seeming or possibly intended chilling effect of consideration of ESG factors. So when we see those specific references, and I think the preamble supports this, it's not that they're breaking new ground or that the administration views it as breaking new ground. It's simply to clarify that, boy, just because these are ESG factors doesn't mean they're off limits, right? A prudent fiduciary, again, if it evaluates it and gives appropriate consideration and views these factors as having a material impact on the risk and performance of the funds, then you're free to consider those, and maybe you should consider those. So I guess to answer your question finally, Dominic, I see the language continuing to be divergent, but I think there is significant alignment between the rules, and so I don't see the kind of environment changing. I hope it does, but I don't see the environment changing in the short term anyhow.
Yeah, no, I think that's right, and I think that's so you can quench my optimism a little bit. But at the end of the day, it strikes me, and I think this is just a general statement that really has nothing to do with ESG. Just generally, when anyone is trying to set out on a course of action, one of the most important things to have is certainty, or some relative degree of certainty. You feel like you know what the rules are. You feel like you understand how to achieve the objectives you'd like to achieve. And, so on the one hand, there's chilling effect of having, say, differing language. On the other hand, there's the chilling effect of simply having the uncertainty. And so I think the message that I pull from your response and from your presentation in that regard, and in particular this last line on this slide, exercising caution and restraint, well, what does that mean? And for me, one thing it might mean for folks who are interested in pursuing these types of options under their plans, thinking about it as, in their fiduciary capacity, that it would be looking for that consistency in language that you just described as between the first final rule and whatever ends up being published in the next final rule. And because, when you can kind of get past the different words and find the consistency, at least in the thought lines, that's going to provide at least the relative certainty that, a planned fiduciary would generally want to have before they decide to, go forward with a course of action that involves ESG options. At least that's my reaction based on your presentation and your answer to that question.
Yeah, and I agree with that, Dominic. I think that's exactly right. Let's find the common themes between the rules, regardless of the precise language that's used, and follow that, right? And if these factors are appropriate, if they have a material impact, then by all means, use those factors to evaluate an investment or investments. But certainly, we shouldn't give short shrift to things that we always talk about, even in basic fiduciary refreshers, right?
Right.
Follow a process and document, right? Let's make sure that we're following those processes. Let's make sure that we're documenting what we do, because again, memories are short. Certainly mine is, and if I don't document, I lose it. And so I think you're exactly right, Dominic, with that comment.
Right, and you as well with respect to, hey, it comes back to first principles, like having a good process and documenting that process, which is a common theme in all the things we'll talk about today, and obviously not a strange theme for anybody who's involved with the risk of fiduciary considerations. So moving on, I think we'll now go on to brokerage windows and talk a little bit about brokerage windows on the next slide. In 2021, the ERISA Advisory Council issued a report titled Understanding Brokerage Windows and Self-Directed Retirement Plans. at the end of the day, brokerage window essentially, we'll talk about it a little bit more detail, but essentially is, providing an option under a plan that allows participants to go beyond the designated investment alternatives that the plan fiduciaries have established with respect to plan investments. So it allows kind of you can think of it as a DIY for plan participants, but because ERISA still applies, we shouldn't think of it as a DIY where anything goes, even if the rules do feel kind of Wild West right now. So in any case, based on this advisory council report, there's continued growth in brokerage windows. We point out Fidelity reported that 23% of its plans offer a brokerage window, which is up a bit from 2016. Vanguard's reported that brokerage windows are more prevalent in larger plans, which is not that surprising. And they report that more than 20% of their plans offer a brokerage window. But when they narrow it to the larger market with 5,000 or more participants, that number rises to 38%. That having been said, despite this increase in the availability of the brokerage windows, and in fact, rather prevalent when you look at that Vanguard number, 38% of those larger plans, we're still only talking about a very small percentage of participants who actually utilize these windows, 2 to 3%. Now, why might you want to offer a brokerage window? Well, that kind of ties back in some respects, and we'll talk a little further about this in the coming slides. Well, one way that we can potentially avoid some of the issues related to ESG investing is to potentially take the plan fiduciaries out of at least the direct line of fire of having selected that ESG investment, and instead, just relying on an ESG investment of a participant's choosing being available for them to select through the brokerage window. So turning now to the, what is a brokerage window? There's, ERISA doesn't define a brokerage window explicitly, although the ERISA regulations under ERISA section 404 do define a designated investment alternative, and in so doing, define a brokerage window as an arrangement, as I noted just before, that permits participants to select investments beyond those designated by the plan. So this idea of being designated by the plan, has been subject to some litigation. And Ed, I know you have some thoughts on at least one of the recent cases in this regard. So I thought I'd give my voice a break and let you give some background on that particular case.
No, very good, Dominic. Thank you. Yeah, it's interesting too, right? You would think, well, this has got to be completely obvious. If it's designated by the plan, it means it's a designated investment alternative. But as Dominic mentioned, there is ongoing litigation, and one example of that ongoing litigation is Harmon versus Shell Oil Company. In that case, there are pending, at least the last I checked, they're still pending, cross motions for summary judgment. And one of the arguments, or the two counter arguments, is that this group of approximately 300 funds, which are listed and documented by Shell Oil, and that documentation is provided to participants, are designated investment alternatives. Now, clearly, there's a difference of opinion between plaintiff's counsel and defense counsel. On the one hand, plaintiff's counsel say, boy, all we have is this very basic language that a fund is a designated investment alternative if it's designated by the plan. Well, plan, you just published a document that lists, and you culled out, among the universe of funds, 300 funds that you've listed and made available to participants within the plan. The fact that you didn't specifically say that they're designated investment alternatives, the fact that you've kind of disclaimed fiduciary responsibility to prudently select and monitor those funds is really immaterial. You've listed those. You've specifically listed and called those funds out to participants. Therefore, they're designated investment alternatives, and therefore you owe duties under ERISA to prudently select and monitor those funds. Now, defense counsel, certainly disagrees with that. These, they consider it an investment or a brokerage window, or as this parenthetical on this page mentions, or a similar arrangement that, it's a broad window of 300 options that have, again, they've narrowed, but again, haven't applied the same kind of fiduciary rigor that designated investment alternatives typically call for. And so defense counsel's view is, no, this is a similar arrangement to a brokerage window, and therefore the obligations, the kind of fiduciary obligations around designated investment alternatives don't apply. Now, where this ends up, I don't know. I don't have a crystal ball, unfortunately, but it raises the interesting issue about precisely what it means to be designated by a plan. So I think more to come on that. We'll have to monitor the progress of that litigation and other litigation, but it does raise that basic fundamental question about what it means to be designated by the plan.
Yep, thank you. And so why is this important? So why do we care if something's been designated by the plan? Well, at the end of the day, there are explicit obligations on plan fiduciaries to prudently select and monitor designated investment alternatives. Explicit language in 404 regulations and regulations under Section 404 that require that. And so the question becomes, well, are the investments that are offered within the brokerage window subject to the same obligations? And those same regulations that specify that plan fiduciaries must prudently select and monitor designated investment alternatives imply, or have been read to imply by many stakeholders, that means that there are no fiduciary obligations with respect to at least the individual investments offered under the brokerage window. Now, I guess stepping back for a second to understand big picture, the fiduciary obligations with respect to a brokerage arrangement that I think everybody agrees on, but Ed, I'll have you check me on that if you think any of this is subject to debate. I think there is no question that a plan fiduciary must prudently select and monitor a brokerage service provider. So that would be, whoever's responsible for essentially the directed administration of the brokerage window. With the question then being, what fiduciary obligations exist with respect to the investments offered within the window? Is it so direct to have a selection and monitoring process? It seems no. Is it that the window as designed needs to be consistent with ERISA's obligations of loyalty and prudence that Ed described at the beginning of this webinar? I think the answer is probably yes. So I'll pause there, Ed, to see if you have any different or other thoughts on that, and then we can go on to talk a little bit more about these brokerage windows.
No, Dominic, I agree with that assessment. And, I think the discussion about, that we just had about the case law and the litigation ongoing, creates these interesting issues, right? Like, how far can you go, right? How far can you go without imposing those obligations? How far can you go in restricting limitations? So if you do so kind of by negative implication, right? You carve out certain things. Does that make them designated investment alternatives? But no, I think the lines are a bit fuzzy, right? And I think it's largely due to the absence of clear guidance from the department. And I think probably intentionally so, right?
Right. Well, it brings me back to my chilling comment before, right? Sometimes there's big advantages to having uncertainty if you don't want something to happen. Now, I'm not suggesting that the Department of Labor has made a conscious decision to purposely not provide guidance, but the Department of Labor may be making a conscious decision not to provide guidance, to the extent that they may not want to see certain types of brokerage windows or brokerage windows at all implemented. And so, the lack of guidance will keep a lot of people away from the option. The lack of certainty will keep people away from the option.
I'm sorry, Doc. I was just going to call back to kind of our initial slide on this discussion point, and that's to the ERISA Advisory Council's report. Right? There was a lengthy report, 50 or 60 pages in my recollection, and views from all sorts of interested parties, including record keepers and lawyers and investment advisors and so on and so forth. And at the end of the day, they largely said, leave it alone. We don't need any more guidance, which somewhat surprised me as I was reading that. And really, the area where there seems to be possibly some appetite for further guidance, at least among these industry actors, is on kind of plans with brokerage window only, right, where they haven't designated investment alternatives. And I found that interesting. Certainly, that would be an interesting area for guidance and would be welcome. But yeah, it was interesting to me that I kind of expected practitioners to say, no, we'd like to have a little more guidance, but at least from those that provided commentary and testimony to the council, didn't seem like so.
Yeah, no, it's a great point. And to me, it kind of, as I think about it, hearing you say that again, it's almost like we're at a certainty equilibrium, perhaps, with respect to brokerage windows. On the one hand, the Department of Labor may now want to give extremely clear guidance to the extent that it may not like the outcome. It may not like what how plans may be able to be designed to potentially escape some ERISA protections that the Department of Labor may want to see applied with respect to, say, the investments in these windows. On the other hand, stakeholders, in particular the plan sponsor stakeholders, they may not want to see more guidance because they may be concerned that, well, be careful what you ask for, right? I mean, you don't ask a question and ask for guidance when you think that the answer might be something you don't want to hear. And so the stakeholders, I think what we're seeing reflected in that advisory council report from the stakeholder perspective is probably a little bit of that, like, hey, we don't need you to monkey around with this. And as we'll talk about in a minute, the last time you monkeyed around and said something here, it really upset the marketplace. So I think that's probably a lot of what's going on. Just to kind of just make sure to set the table in terms of how these brokerage window arrangements typically work, just for those of you who may not have experienced them. I mean, the most typical case is that the record keeper, is the one who actually is selecting the brokerage service provider, even though I just said before that, well, clearly there are ERISA fiduciary considerations related to a named fiduciary, a plan named fiduciary selecting a service provider, the brokerage service provider. The fact is that frequently comes bundled with your record keeper. And so, it's very important to the extent that you wish to, have or offer or may wish to have or offer a brokerage window, that when you're looking at your record keeper, that you're evaluating, okay, well, can this record keeper do that? And, to the extent they can, what contracts, arrangements, options do they have with respect to brokerage service providers? It does put a little bit of attention, though, right? Because the named fiduciary really needs to be analyzing and monitoring and providing oversight with respect to the brokerage service provider. But yet, if to the extent that that's tied together with your record keeper, it can put you in an awkward position of potentially being comfortable with or uncomfortable, say, with the brokerage option, a brokerage service provider, even though from an ERISA fiduciary perspective, you might be quite content with the record keeping services. So, I mean, looking at this slide with respect to fiduciary considerations, I mean, the decision to offer a window fiduciary or not, well, as Ed mentioned in the start of the presentation, we typically see named fiduciary committees, and as also has been mentioned in prior webinars in this series, we typically see named fiduciary committees serving as plan administrator, an investment fiduciary, or maybe there's more than one committee for these roles. Well, if that committee is the one that's making the decision within the scope of its delegated duties to offer a brokerage window, then it would seem that there would be a fuller range of fiduciary duties regarding the brokerage window, at least on the design front. In other words, if it's the fiduciary that's deciding within the scope of its designated authority to offer the window, well, now the fiduciary is making decisions in its fiduciary capacity with respect to all aspects of the window, including any constraints that may be there. If instead the committee is implementing a plan sponsor decision to provide for a brokerage window, which is there as a matter of plan design, then now the question comes into play, well, okay, does that mean that there's a lower fiduciary standard? Maybe not. I mean, at the end of the day, right, the implementation of any plan term, well, that's okay to do as long as the term isn't contrary to law or the way that you're implementing isn't contrary to law. And of course, we know in other contexts that it's very clear that contrary to law includes if it's contrary to ERISA's duties of prudence and loyalty. So, either way, you're going to have significant fiduciary duties associated, at least with respect to the design, the framework of the window, the monitoring and oversight, if you will. Then the question becomes, well, is there a duty to analyze outcomes under the brokerage window? How is the window being used? Are participants suffering losses as a result of the availability of the window? We look at this second sub-bullet under the second main bullet here, a fiduciary's decision not to offer any designated investment alternatives. And this is a quote from the Department of Labor, raises questions under ERISA Section 404, fiduciary duties of prudence and loyalty. Well, we could change that quote pretty easily to say a fiduciary's decision to offer a brokerage window raises considerations or questions under ERISA 404 with respect to general statutory fiduciary duties of prudence and loyalty. So really each one of these sub-bullets could end with a question mark.
Dominic, just to jump in too, right? In all this, against the backdrop of some of the information you shared on the first slide, which is, although a significant portion of the plans out there offer brokerage windows, very few participants and very small percentages of the plan's assets are invested using the brokerage window. So we have this issue where, as you mentioned, many record keepers have a single brokerage window vendor, right, that they use, or maybe a couple at most. And so it's almost the tail wagging the dog, right? I mean, if when we're thinking about a very small proportion of the participants and the dollars being invested in this, how much consideration should we take to the brokerage window and those issues, in light of the fact that now, if we do so, we may be restricting the universe of record keepers that we use.
Yep. No, it's a great point. So flipping to the next slide, at least in terms of things that I think we know, certain decisions made in implementing a brokerage window are clearly fiduciary, as we pointed out, selecting and monitoring the brokerage window provider, including the reasonableness of the fees, both record keeper side and brokerage provider fees, constraints on investment within a brokerage window, whether to impose limits that are not set forth in plan terms, or whether to follow plan terms that include limits. So basically the question is, well, to what extent are fiduciary duties implicated by a universe of available options under the brokerage window, and what type of fiduciary obligations exist, if any, that would require an affirmative constraining of that universe. Another way that you can constrain is limiting the percentage of assets. And unfortunately, Department of Labor guidance has only added to the confusion. Looking at what happened back in 2012, there was these are the FAQs that came out in 2012 after a series actually of there were 404A and 404C and 408B2 regulations that were published, and there was a series of frequently asked questions that came out in connection with this. And as part of that, the Department of Labor set the world on fire by basically saying, if through a brokerage window or similar arrangement, non-designated investment alternatives under a plan are selected by significant numbers of participants, an affirmative obligation arises on the part of the plan fiduciary to examine the alternatives and determine whether one or more of the alternatives should be treated as designated for purposes of the regulation. In other words, should it be subject to the same fiduciary obligations that we already described exist with respect to designated investment alternatives? And the it in that case being the particular investments in which, say a substantial number or significant number of participants may be choosing to invest. Well, that caused a heck of an uproar. And, so there was a tremendous amount of pushback from stakeholders. And so we got a revision of, this is a FAB, a Field Assistance Bulletin 2012-02R, where the department clarified a little bit. They clarified a little bit. They say, well, there's no requirement to have any particular number of designated investment alternatives, and there's nothing that prohibits the use of a brokerage window, self-directed, whatever you want to call it. That's all good. And oh, by the way, we didn't mean to change any of the rules regarding 404C, which provides, an affirmative defense. It provides fiduciary protection with respect to designated investment alternatives. But then they go on to say, and it's not actually on this slide, they go on to say this caution, but you are still bound, you being plan fiduciaries, are still bound by ERISA sections 404A statutory duties of prudence and loyalty to participants and beneficiaries who use the platform or the brokerage window. So that's their shot across the bow, basically, that we're backing off, but not that much. So that kind of leads and actually gets us right to this crypto curveball, as we call it. There was a compliance release that was issued just this year related to cryptocurrency investments. And, we're not going to talk about, using cryptocurrency investments as a designated investment alternative, because I don't think anybody has gone to that point now. But some have, opened up, their brokerage windows to cryptocurrency options. Well, the Department of Labor released this compliance assistance release that basically gave us all the reasons why they hate cryptocurrency as an investment in a 401k plan. And then they went on the next slide, you'll see, to say, and oh, by the way, we're going to start investigating folks who do this. And if you do this, and whether it's an investment option, which again, I'm not aware of anybody who's doing that, or through a brokerage window, you should expect to be asked questions about how fiduciaries, that's the you, can square, I don't know what square means, their actions with their duties of prudence and loyalty. That's the key phrase. It's exactly the same phrase as the Department of Labor used in their 2012 guidance, that some consider at the time to be backing off. And so, I think, where does it leave us? Well, we're kind of in the same position we've been in for a while. We've got the uncertainty related to what it means to be designated by the plan that Ed talked about. We've got questions regarding how we should be as plan fiduciaries, whether it's set forth in plan design or whether plan fiduciaries are choosing to implement brokerage windows that might include crypto or not. Should they be excluded? Should other things, individual stocks, be excluded? I think lots of people might say yes. Is this DOL returning to its position under the FAB? Maybe, or maybe they never left that position. And maybe when they published 2012-02R, that little parting shot about prudence and loyalty is actually where they've been all along. And then we have the final question and Ed alluded to this in one of his responses, about, hey, can we really have a brokerage window only? And even there, a lot of plan sponsor side stakeholders have said for a brokerage window only plan, gee, Department of Labor, we've got some concerns about that. Maybe you might want to provide some guidance on that. So our takeaways, considering whether a brokerage window is appropriate for the plan population, even if it's in plan terms, plan fiduciaries might be in a difficult position. This may be a fiduciary consideration. But that having been said, when you restrict access, if you chose to restrict access, that can raise code non-discrimination issues. What do you do with investments available through a window? Well, probably not a good idea to specify specific investments. That might get you into a designated investment alternative situation like Ed described with the Shell case. Don't limit the investments to a single fund provider or otherwise significantly limit the universe, but do consider reasonable restrictions, individual stocks, company stock, cryptocurrency. Plan fiduciaries, you should implement your brokerage window in accordance with plan terms, just like any other plan. That means that the ERISA prudence and loyalty considerations apply, and you should be prudently evaluating, selecting your window, your vendor. You should be carefully considering your participant population, whether education is needed, and you should be monitoring new developments. Just a couple parting words on managed accounts. I know we're running out of time. Apologize for that. We've got a similar situation with respect to some of the uncertainties related to managed accounts, with the exception that managed accounts are clearly offered by plan fiduciaries. And so typically a managed account is going to be run by a 338 investment manager. And one of the biggest issues I see in managed accounts, or concerns I have with respect to managed accounts, is actually set forth in the next slide. And that's this idea that managed account providers need to be carefully selected and monitored. And just like, or I said it's similar, just like with respect to brokerage windows, that's very difficult because often the managed account provider is tied to the hip with the record keeper. And so it can really cloud the ability to do these types of analyses. But one thing you don't want to do is just ignore them. It's not a set and forget. There does need to be an ongoing monitoring process in accordance with the risk fiduciary duties. So, other things to consider with those duties are, are folks actually using these managed accounts? They're paying an extra fee for it. Consider offering it on an opt-in rather than a QDIA. And then on the next slide, evaluate whether managed account fees are subsidizing the record keeping fees. This can be a fiduciary consideration. Be wary of deals. If it looks too good to be true, it is. If one part of your participant population is effectively subsidizing the other part, you've got some things to think about. And, you want to be really careful in the way you consider your participant communications in this regard. And with that, I think we should wrap up based on our timing. Ed?
Yeah, Dominic, thank you for those comments. And yes, we are at the top of the hour. Thank you all for attending our presentation. As mentioned earlier, we will send today's recorded webinar and slides to all registrants in approximately 2 business days. If you have questions we were unable to get to, and I didn't see any referenced, but if you do, please reach out to your Thompson Hine attorney. If you aren't currently a client, please contact me or Dominic, and we will discuss available options to address your needs. Thank you so much for joining us, and enjoy the rest of your day.